What up, peeps? I gotta make this quick video. I was looking into the Georgia law codes, if you will, concerning express trust. I'm kind of doing a little research on an express trust, um, and I think for the most part, from what I'm seeing, most of us have we've overcomplicated how to create a trust. We got so many people on the internet. They're teaching about how they're gonna create you a trust. I'm gonna do this for make you a trust and acting like that. Like creating trust is so complex to the point to where you think you need somebody that knows some they have some type of esoteric knowledge. Esoteric that basically like as if they like it has to be worded of course it has to be worded a certain way, but they make it look like as if like you can't do it yourself. You can actually do it. You can do an express trust yourself. So I thought I'd kind of look into my state statutes here in Georgia. Um, just kind of read exactly what the state laws. Keep in mind these codes are given the force of law. So people, we've been trained by many so-called gurus on the internet to not accept these codes as the to be used as the law to kind of to help you get your remedy. Keep in mind they're using the same codes to enslave you in the courtroom. They're using the same codes. And if you look in these codes, you also find your remedy as to how to get free from the things that they're doing to us. So we have to get away from the mentality of running from the codes, acting as if we can't use the codes to get remedy, as if they don't apply to you. Nobody can apply these codes to our lives except the living men and women. Okay. So yes, it's speaking commercial language. However, they do apply to you because you're the one that's playing the game. Okay. Now, I can't express that enough. So I'm gonna keep bringing that up, so you always understand. You need to be looking into your state codes, the codes in the state in which you live in, so that you can actually apply the things that it has that's available to you, so that you can get free from whatever it is you're fighting against. Okay, back to the topic. Express Trust here in Georgia, uh, OCGA. What's the code of 50 subsection 53-12-20? Says an express trust shall be created or declared in writing, let you know off the rip, in writing and signed by the settlor or an agent for the settlor, acting under a power of attorney containing express authorization. Now, I'm gonna pause for a second, so I'm gonna show you what settlor is, so you understand that you are the settlor. I'm gonna minimize this real quick. Let's see. So you understand what a settlor is. Settlor legal definition. Okay. As you can see, Cornell University right there. A settlor is the party that creates a trust usually the donor. The settlor transfer legal title in some asset to the trustee. In, in the case of an inter vivos trust, never heard of vivos trust. The settlor can also be the beneficiary. Okay. Matter of fact, let me see right here. Here's the free dictionary. The person who creates a trust by a written trust declaration, called a trustor in many particular Western states, particularly Western states, and sometimes referred to as the donor. Okay, they use them interchangeably sometimes. Okay, the settlor usually transfers the original assets into the trust. So it lets you know, get out of here. Lets you know. I hate when people do that when I'm doing a damn video. Okay, um, so it lets you know when. Let's see. Go back to what I was reading. Damn, how did I lose it? I just go back like this. The hell. I just go back to it like I do this. Okay. I'm just going to. Okay. Back to this. As you can see, you are the settler because you're the one creating the trust. Okay. So let's go back to let's read A again. Let's read A again. An express trust shall be created or declared in writing and signed by the settlor, that's you, or an agent for the settlor, acting under a power of attorney containing express authorization. B. An express trust shall have ascertainable with reasonable certainty. Number one, it's telling you exactly what what an express trust is supposed to have. And these 5 components right here. Okay, here we go. Number one, an intention by a settlor, that's you, to create such trust. Number two, trust property. You got to have property. It has to be referring to some type of property within that trust. Number three, except for charitable trust, a beneficiary who is reasonably ascertainable at the time of the creation of the trust, or reasonably ascertainable within a period of the rule against perpetuities. Number four, a trustee, somebody that's operating it. Okay. And number five, trustee duties specified in writing or provided by law. So you got to have in writing. You're actually expressing what the duties of the trustee is. Okay, so that's all it is to create a trust. That's all it is. As a matter of fact, when I was speaking about registering the name, if you go back and read the registration statement that I've actually given before in the past, that's actually a trust as well. The registration statement itself, because it tells you that it specifically expresses that John Doe, upper lowercase, is conducting business. He's the beneficiary and grantor. He's the grantor beneficiary of the particular business, the all caps name, which is the business. That's actually the property. And the upper lowercase name is the trustee. That's the one that's conducting business. The business name itself. The business is actually the property, and you're actually expressing what's the nature of the business. You're telling exactly what your duties are. What are you doing with that name? What type of business you're doing. You know what I'm saying? That's what that registration statement is. A trust. It's an express trust. It's a type of express trust. There are different types of express trust, but you got to have these components in there in order for it to be a trust. Okay, that's another reason why it works to keep it. They can't violate, can't create a body attachment once you register the name. In your court case, they can't create a body attachment and try to make you something you're not. Okay. C. The requirement that a trust have the requirement that a trust have a reasonably ascertainable beneficiary shall be satisfied if under the trust instrument the trustee or some other person has the power to select the beneficiaries based on a standard or in the discretion of the trustee or other person. Okay. I just thought I'd make this quick video. I'm gonna try to make it short and sweet. I might want to let me see if I can go look into another state and see if I can find some. I'm gonna pause this video and see if I can find another state just to see what I can find. Hold on a second. Before I do that, I thought I'd go to this other one real quick. I was searching and I thought I'd go through some more of what it's saying about an express trust here in Georgia. Right here, this is 53-12-21. Notice right here it says formal and precatory words. Say no formal words shall be necessary to create an express trust. Off the rip is telling you don't have to be all fancy and know how to, you don't have to have a degree to create an express trust. Okay, you don't have to have, all these special skills that people, you guys are that are beginners when it comes to learning, how to do this stuff. When you hear these people using talking about trust, and then you don't know what a trust is, and you don't have a clear understanding about what one is and how to create one, and then you paying people all this money to create you something you could do on your own. It tells you right here, no formal words should be necessary to create and express trust. That's the first thing it tells you. Okay, words otherwise precatory in nature will create a trust only if they are sufficiently imperative to show a settlers, that's your intention to impose enforceable duties on a trustee, and if all other elements of an express trust are present. So as you see, it's not that hard to create a trust. We create trust all the time, don't even realize it. Okay, I'm gonna back up a little bit. I'm gonna go back to this again. Let's see. Hmm, let's see. Revocable trust. I'll do that one in another video. Let's see. Where's express trust? How did I find it? Okay, that's 12, 21. There we go. 21, let's see, 22. Let's see, trust purposes and conditions, terram, capacity of a settler. I'm going to go through these. That's what I'm going to do. I'm going to go through these, see what it says. Okay. A trust may be created for any lawful purpose. That's pretty good. 23-12-22. Trust purposes and conditions in terram. I'm going to look that word terram up real quick. I'm going to pause this real quick. Hold on a second. Okay, you can see right here, Black's Law Dictionary, interim. In terror or warning by way of threat. Applied to legacies given upon, how do you put that like that together? Given upon condition that the recipient shall not dispute the validity or the disposition of the will. Such a condition being usually regarded as a mere threat. Okay, that makes sense. Okay, let me go back to where I was. I'm using a different phone, y'all, so I'm really trying to. Going back to where I was. Okay, what was I? 22. All right, back to this. I can see where it says interim. Okay, I'm gonna read B again. The condition interim shall be void, unless there is a direction in the trust instrument as to the disposition of the property if the condition interim is violated. In which event the direction in the trust instrument shall be carried out. Okay, now it makes sense. Okay, now I'm gonna back up to the next one. So it's always good when you don't understand what these words mean. You gotta look them up. Don't be scared to step back and look these words up. They may not mean what you think they mean. So you gotta always get clarity by looking the words up. There's no, don't have time to be being lazy no more. Let's see, we're at 23 now. 53-12-23. Capacity of a settlor. That's what your capacity is. You are the settlor. We looked that up. Remember, a person has capacity to create an inter vivos. I'm gonna look that up too because I've seen it twice now. An inter vivos trust to the extent that such person has legal capacity to transfer title to property inter vivos. A person has capacity to create a testamentary, I don't know why the hell I say it like that. A testamentary trust to the extent that such person has legal capacity to devise or bequeath property by will. So you got to have the authority to be able to do that. Okay, I understand that part. Number, let's see. So you can't be a settler unless you gotta have that. You gotta have a particular interest in that particular property in order to be able to in order to create that trust. You can't make a trust with with respect to some property. It's not that you don't have any interest in, you don't have ownership of. It had nothing to do. I can't do it for I can't name myself. I can't be the settler for somebody else's stuff. The settler of a trust concerning somebody else's property. You know what I'm saying? As far as me taking, being the one to create the trust, I can be a beneficiary named by whoever the other settler is, somebody, whoever else, whoever the owner is of that property. That's the one that's gonna create the trust. You know what I'm saying? Or the it don't have to be the owner. It could be someone that's appointed to operate in that capacity by the one who's actually the real owner. Okay, number 24, non-merger. I don't know what that is. Hold up. I said something about vivos, didn't I? Let me look that word up. Inter vivos. That was interesting. A person has capacity to create an inter vivos trust. No, I'm gonna look that up. Look, that sounds like it's another video, but I'm gonna look that up. Not that I ain't gonna do that right now, cause I'm trying to really give you guys a clearer understanding about creating an express trust. Okay, so you understand the stuff is not as hard as we've made it over the years. You can create your own trust. And we create them all the time and don't even know it. No trust shall be invalid or terminated, and no merger of title to trust property shall occur merely because the trustee or trustees are the same person or persons as the beneficiary or beneficiaries of the trust. So just because you're the one operating the trust, you're the one operating as a trustee, you're the one operating that trust, don't mean that you can't be the beneficiary. It does not invalidate the trust. You can still be the beneficiary. You could be the beneficiary and the trustee at the same time. Okay, so it does not make it invalid. It does not terminate it. Okay, just like me talking about the registration statement, I name myself my proper name, upper lowercase name, as the grantor / beneficiary. I did that in my registration statement. So the grantor is also used interchangeably sometime with the term settler. You know what I'm saying? So when you see that, when you see that a grantor and a settler can be pretty much the same, they're one and the same. They can be used. They can be used as one and the same. Okay, in many cases, and the beneficiary are the same person. It does not make the trust invalid. It does not terminate it. So you can still be both. Okay, so this is stating that this is exactly what it's saying. Okay, now let's back up. Go back to the other one. Transfer of property to trust. 53-12-25. Transfer of property to trust shall require a transfer of legal title to the trustee. Okay, let's see. It got to be a transfer. It's basically saying it's a transfer of property. Okay. For any interest in real property to become trust property in a trust of which any transferor is the trustee, the instrument of conveyance shall additionally be recorded in the appropriate real property records. Okay, that's the what you call it, the records of deeds office in the county. That's where that can be recorded at. A lot of people tell, I've heard people say where you can actually, send it to yourself, registered mail. You know, you can try that, but I don't see how you're gonna prove that that's an actual record in a court case. If you record it in the county records, and there's this rule called the first in time, first in right rule. You record that thing in the county records first. Anybody try to record it after that, they're behind there. They did it after you did it. So your recording would be superior to theirs because you did it first. Okay, right here. This is telling you right here, for any interest in real property to become trust property in a trust, of which any transfer is a trustee, the instrument of conveyance shall additionally be recorded in the appropriate real property records. So you got to record that thing, get it recorded. You know, when you get it recorded in the Register of Deeds office, now you can get a certified copy of that trust and you file it into your court case. That is your evidence. That is your prima facie evidence, which is evidence is valid on its face. That's what it means by prima facie. I think that's what it means, y'all. Matter of fact, I'm positive that's what it means. Prima facie is valid on its face. You know, when you that's when you're proving that trust. It's a certified copy of that trust. If you get it, get a certified copy of it from the records of deeds office, you can always file it into your court case to prove prove whatever it is you're saying in in your paperwork. Okay. Right here it's telling you it needs to be recorded in the proper and in the appropriate real property records. Okay. And that's where you can record that stuff in your county. Okay, here we go. This is not just for registration of trade name. This is for any property. Okay. It's for any property. Okay, so I'll let that sink in for a minute. Any property. Here we go. Now, that was in 25. Now, 53-12-26. Additions to trust property. Property may be added to an existing trust from any source in any manner if the addition is not prohibited by the trust instrument and the property is acceptable to the trustee. Okay, so the trustee agrees to that. You can add it if the original instrument don't prohibit the adding of more property, then you can go ahead and add more property to that particular trust. All you're doing is, I guess you can just do an amendment or whatever, however you choose to do it. Okay. Next, go back. Construction, parole evidence. Or peril evidence. I'm saying parole. Peril evidence. And parole. When the construction of an express trust is at issue, the court may hear peril evidence of the circumstances surrounding the settlor at the time of execution of the trust and peril evidence to explain all ambiguities, both latent and patent. Okay. You know what ambiguities are. That's when the words are unclear as to what the trust is. There's some terms in there that are not clear. They're not clear and direct to the as to what the trust is really saying. What the settlor, whoever wrote this, whoever created the trust, what they meant when they said what they said in the document, in the instrument. Okay, let me go to the next one. Trust for animals. I read it. Yeah, I guess I read it. Damn, it's a lot. Here we go. A trust may be created to provide for the care of an animal that is alive during the settlor's lifetime. A trust shall terminate upon the death of such animal, or if the trust was created to provide for the care of more than one animal alive during the settlor's lifetime upon the death of the last surviving animal. That makes sense. So if you got, you can have more than one dog and whatever animal in there, and that trust is it still stands until that last animal is passes away. Okay, a trust authorized by this code section may be enforced by a person appointed in the trust instrument, or if no person is so appointed by a person, if no person is so appointed, by a person appointed by the court. Okay, a person having an interest in the welfare of the animal may request the court to appoint a person to enforce the trust or to remove a person appointed. Okay, that's clear. Upon termination of a trust authorized by this code, the trustee shall transfer any unexpended trust property in the following order. Number one, as directed in the trust instrument. So you're not, if the trust instrument has specific instructions, they have to follow the instructions in the instrument that's stated in the instrument. Number two, if the trust was created in a non-subsidiary clause in the settlor's will or in a codicil to the settlor's will, it's under residuary residuary. I'm just fucking up words. Residuary clause in the settler's will. And number three, if no taker is produced by the if no taker is produced by the application of paragraph 1 or 2 of this subsection to the settlor if living, and if not, to the settler's heirs, whoever can inherit it, as determined under code section 53-2-1. Okay, so that is pretty much it for this video. I thought it was just, I just had to go over this because it really needed to be. We have to be willing to look in your state codes and see what it says about express trust. There are different types of trust. Express trust is just one of many types, and it's telling you exactly how to use one. How to create one. What the courts say, how the validity of them. I mean, and as you see, if you go and look in your state codes, you'll see. And if you're here in Georgia, you got this video right here at your disposal. So, and if you're in any other state, go just look in there, and most likely your state's going to say the same thing. So you just have to be willing to. Let me back up. I don't want anybody to get lazy and think automatically because I said that. Don't look in your state codes. Look in your state codes and see what your state says about your codes and how to about express trust, how to create one, and where it should be recorded or whatever. Because all states have their own jurisdiction, so they don't all do the same thing the same way. So you got to look in your state codes. No being lazy. Got to stop being lazy. That's the reason why I stopped answering a lot of calls, because I don't like dealing with people that's lazy. They got to start doing the work. Okay? So I'm not letting people blow my phone up like I was before, because a lot of people don't want to do the work. They want me to do it for them, or they don't, and I don't, and they know that I don't charge them. So I'm not letting nobody use me like that no more. If I got to type up somebody's stuff, I'm charging you, because I'm showing you how to do it. I'm showing you exactly what your state code, what Georgia state code say, and I'm telling you how to find the information. And if you can find you're too lazy to find the information and you want me to do it for you, I'm gonna charge your ass. It don't make sense for people to be lazy and don't want to do their own stuff. Okay, so you got to do it. Do the work. As you can see, an express trust is one of many types of trust, and it's not hard to put this stuff together. Okay, I don't want nobody wasting my time like I was letting them do before. My heart is really into helping people, but I don't like my time being wasted. If my time being wasted because I sat here and spent countless hours talking to individuals, hours at a time, day after day, week after week, month after month, and then months go by and they never apply the information, never do it, because if they're letting other people fleece them, and they're bouncing from so-called guru to so-called guru all over the internet, cluttering their minds with all types of information. They never apply what I gave them for free. So I'd rather not my time be wasted like that. So if I got to do your work for you, I'm gonna charge you. EmRôs is not doing this stuff for free no more. Okay, I don't have a problem talking to someone, but I'm not finna do your work for you. You know, if you're gonna let the videos do all the teaching. Okay, if I gotta spend my time talking to you all the time, I'm not finna do the work for you. You got to do the work. Okay, so okay. I'm not gonna go into no rant. I just thought I'd make this video to show you guys how to do a trust. The trusts are very simple. Okay, so go back and share this video. Don't forget to hit the thumbs up and subscribe, because I'm gonna keep on doing this. I'm gonna go back to making more videos and posting more videos, teaching this stuff as thorough as possible. Hopefully you can, you all can get it on this go around. Okay. All right, y'all. EmRôs signing out.